All right, our final argument this morning will be case number 28510, Bernadette Kolar versus David Kolar. We are running early. Do you expect, does council expect anybody to show up for these arguments to observe?
No, Your Honor.
We can wait till noon if you'd like, or we can get started.
Your Honor, Mr. Lowry may come, but we don't need to wait for him.
Okay. Then why don't you come forward and we'll get started here. Each party will have 15 minutes to present your arguments. Appellant may reserve up to 5 minutes for rebuttal. If you wish to do that, just let me know if you remember how much time you would like to reserve. The arguments that you will be making today are recorded and will be posted on the court's YouTube channel, so please identify yourself, the party that you are representing. Also keep your voice up and try to remain behind the podium. If there is a need to discuss children, we prefer that you refrain from using the child's actual name and just use initials. And we have read the briefs in this matter. We're ready to proceed if you are.
Thank you, Your Honor. Your Honors, my name is Jonathan Rich. I represent the appellant, David Kolar. I'd like to reserve 3 minutes for rebuttal.
Very good, thank you.
Your Honors, the first assignment of error I want to discuss is the trial court's denial of my client's due process rights to a hearing on the issue of the attorney fees that were awarded in this matter. At the conclusion of the trial court set a due date for both parties to submit closing arguments contemporaneously. Parties agreed on a short extension of that date, and on that date, the appellant filed his closing argument as well as his attorney fee affidavit as required by the trial court. The appellee did not file her time records and information regarding attorney fees on the due date that was scheduled and agreed to by the parties in the court. Days later, after the closing arguments were submitted, the appellee submitted her timesheets to the court. The appellant asked the trial court either to strike the submission of the timesheets that were submitted, or an alternative to grant the appellant leave of 7 days to respond, and the trial court denied both of those proposed motions, or both of those motions, not proposed motions, both of those motions and the proposed entries that were submitted. We submitted the two alternatives, either strike it or give us an opportunity to respond. The trial court denied both of those opportunities to us, and then went ahead and issued an order for $90,000 of attorney fees to be paid by the appellant to the appellee.
So the only thing that was missing from the affidavit was the timesheets, because both parties agreed to submit affidavits in lieu of having a hearing. Nobody requested a hearing, correct?
It was not agreed to that we would not have a hearing, Your Honor.
Did you request a hearing?
We didn't specifically request a hearing, nor do we think a specific request needed to be made under the local rule. The local rule 25 provides that, well, it provides for a hearing. It says in a couple different places that upon submittal of the affidavit there would be a hearing. And in fact, the submission of the time came after the trial. So there was no opportunity to cross-examine, present any evidence in regards to the attorney fee issue at all.
So let me get this right in my mind. There was an agreement to submit affidavits on attorney's fees.
And the bills.
And
It
the
was
bill.
all to be submitted to the court.
You anticipated a hearing because of the local rule, but
Correct.
did not request a hearing.
Correct. We did. It was at the end of the trial, the judge said, do this. Submit the affidavits at the time of the closing argument. And we did that. We submitted our bills, we submitted our closing arguments. The appellee submitted hers late, not timely, not without leave of court, and then the trial court barred us from any type of even a written response, let alone an oral hearing, which we believe local rule 25 provides. In a couple different places, local rule 25.02 indicates that there will be a hearing.
All right, thank you.
And we believe that the court could not make a decision on attorney fees under 3105.73 without having a hearing, because the starting point is to determine the reasonableness of the hours expended. the affidavit of the appellee's counsel, which was submitted with the closing argument, is mostly about the qualifications of appellee's counsel. There is little to no information in that affidavit regarding the time actually spent, for what purposes, and that would enable the court to determine the reasonableness of the fees. Then came later these timesheets. But we had no opportunity to cross-examine appellee's counsel regarding the timesheets. More importantly, since there was no hearing, appellant was not given the opportunity to provide other evidence regarding the hours billed. We couldn't produce, an expert. We couldn't do anything to address this issue with the court. So,
am I correct in that there was an opportunity to respond? Wasn't there a 7-day
Denied.
opportunity to respond?
denied. No, we were denied that. The motion to strike was either was pled in the alternative. It was a motion to strike, or in the alternative, give us an opportunity to respond. There was one order issued denying both of those options. It's a December 2016, I think December 20th order, but I may be wrong about that exact date. But it denied that opportunity. So we were not given any opportunity on this issue to present evidence. As a result, we believe the trial court erred in granting a $90,000 judgment for attorney fees. So we believe that that order should be reversed on due process grounds, but if not, it should be reversed on the abuse of discretion committed by the trial court, because it's unreasonable and unconscionable number. It's impossible to determine how the trial court figured that number out, why it was ordered. There's no discussion in the trial court's order of the time alleged to have been expended by the appellee counsel, which is supposed to be the starting point for any reasonable fee. Furthermore, when it gets down to the equity of this matter, the appellee, alleged there was some, delay, and there's some reference to delay in the proceedings as a result of the appellant, which we dispute. But there's no quantifying how much time was expended due to this alleged delay. And there's nothing in the trial court's order that this court could look to see, yeah, that makes sense, that's why this number 90,000 makes sense. There's just nothing there. Furthermore, the appellee received assets of about $2.5 million in this case. So when you look at the equities, there's no justifiable reason why the appellant should pay nearly all of the fees and expenses incurred by the appellee. Why the appellant should pay nearly all the fees incurred by the appellee. All right, my second assignment of error that I wish to discuss with you is the open-ended spousal support award. In this case, again, we do not believe the trial court, made any effort to actually analyze the relevant case law factors that the court is to look at when determining whether a spousal support award should be open-ended with no termination date. And as she only listed facts in her decision, there's really no analysis. So, going through the judgment entry, yes, we can say that this party submitted evidence of this income, and this party was this many years old, and this party has no health issues. Yes, she went through the facts, but when you actually look at for analysis, there's no analysis. In other words, the trial court is supposed to look at whether this is a marriage of long duration. Did she do that? Well, no. I mean, she said it's a 24-plus year marriage, but really the parties had been separated for over 4 years. There was an absolute de facto termination of this marriage. This case pended for over 4 years.
Case law says 20 years is a long marriage, doesn't it?
Well, yes, there are cases from this district that say that is a marriage of long duration, and I think one of those, but I think you have to look at all the different factors. Marriage of long duration, if we're going to say a 20-year marriage is long duration, I don't necessarily agree that that is a marriage of long duration, but I know there's case law out there. But in some of those cases, you have other factors, and the longness of the duration Again, I think the trial court erred even so in calling it a 24-year marriage and not giving credit for the 4 years that this matter was pending pre-decree. But there are other factors the court is supposed to look at under the case law. The second factor is whether the parties were of advanced age. And I don't know what that means, and I don't know if there's any case law out there saying what that means. But I think that goes a little bit towards health. I mean, both these parties were healthy people. There's no evidence that they could not work. The wife testified she could work, had no health ailments that made it impossible for her to work. She was 55 years old. My client was 65 years old. I don't think either of them were of advanced age. The next factor the court was supposed to analyze was whether there was an opportunity to develop employment outside the home. Again, the evidence that the court didn't analyze would lead the court, should have led the court to conclude, yes, there was an opportunity. In 2013, the temporary support order said the appellee should seek employment. She never did. She testified at trial. No, I never looked for jobs. I didn't do anything in the 4 years this matter was pending. I didn't seek an education. I didn't seek a job. I did nothing. So it's not that she has to take advantage of the opportunity. The criteria is, was there an opportunity? And again, the last factor the court was supposed to analyze was the resources, ability, and potential to become self-sufficient. And again, we've got an award here of $2.5 million going to the appellee, plus a substantial spousal support award. She has the resources to get educated, to retrain, whatever she needs to do to become self-sufficient. These are the factors the court should have analyzed. And because she didn't analyze those factors, she didn't come to the right decision. We believe her decision is arbitrary and unconscionable and unreasonable. You know, for a 20-year marriage for a 55-year-old spouse to have a lifetime award. Furthermore, the court really should have looked at the financial situation on my client's side. One of the spousal support factors is the parties' respective incomes. In this case, my client had only had $100,000 of earned income and $300,000 of income from his investments. So even if you were to retire and not plus my 3 minutes.
No, cool.
Okay. All right. Well, let me move on to the tax liability very quickly. And I would just say this on the tax liability is that the court did nothing about it. There was a nearly $200,000 tax liability. My client agreed to pay it, but the trial court should have, and we presented a lot of evidence on this because we had the captain testify about the tax liability. The court should have taken consideration of it either in the property division or in the spousal support. The only mention of it is in the spousal support where the court says, well, the husband says he can't afford to pay a lot of spousal support because he has a tax obligation. But when you look at the little chart that's attendant to the order, the only thing she took into consideration of was housing expenses. So when it comes down to it, she mentions it, but did nothing to reduce spousal support due to the tax, and she did nothing to make the property division accommodate this huge tax liability that my client had to pay. I'd like to reserve the rest of my time. Thanks.
All right. That's 2 minutes and 49 seconds.
Thank you.
Your Honors, my name is Ken Gibson. I'm here on behalf of the appellee Bernadette Kolar. First of all, I'd like to apologize because I did get it wrong with regard to the court granting a 7-day extension. I misread that order. The court did, in fact, as the appellant submitted, deny the extension of time.
So that must be why I recalled something about a 7-day extension, and
And I wanted to clarify that. However, the court did not deny the appellant the opportunity to respond, merely an extension of time in which to respond after ruling upon a motion to strike. The defendant did respond in his motion to strike. And the defendant said in his motion to strike, he didn't allege any issue with the time, he alleged issue with the payments that were received. He wrote, plaintiff claims to have only received the following funds to pay her attorney's fees and expert fees, and then goes on and lists those funds. Plaintiff must have forgotten about additional payments, and he sets forth that. That's all the substance of what he alleges is something that requires a response. And in fact, the payments that he says that the plaintiff must have forgotten were shown on the documents submitted by the plaintiff and her attorneys. Those payments are there. The court had those in front of him. There was really no dispute of anything that he alleged in his motion to strike or his motion for additional time.
What about his
That
Rule
would require a hearing.
25 argument that a hearing was required?
Well, Your Honor, first of all, I cited many, many cases where it says that a hearing is not required and it can be waived. In this case, there was an express discussion on the record that the attorney's fees would be determined by attorney fee affidavits. Both parties agreed. No mention of a hearing, no request for a hearing. And they both submitted affidavits. Admittedly, the timesheets were submitted separately and somewhat later, but he did respond after that with his motion to strike. If this court rules that a hearing is required in every instance under Rule 25, which is not the practice of the Domestic Relations Court and is not consistent with this court's prior rulings, as I've cited in my brief, then it's going to make a pretty substantial change in the procedure below. Just need to understand that. I do not believe that the rule says that a hearing must be held in every case or that it cannot be waived.
Thank you.
Okay, now, even now, in his appellate brief, the appellant has not demonstrated any issue with the time, hasn't said anything about what he could have presented at the hearing other than we could have had a hearing. There's nothing in either the record below, in the motion that he filed, or in the brief to this court to demonstrate that he was prejudiced in any way by the failure to have a hearing. He has a burden of showing that he was prejudiced or that there was something that he could have raised in specific. I mean, the timesheets are in the record. He could have said, well, you know, I dispute this time, or I dispute this time, or I dispute that time. He hasn't done that. He's merely said, I could have had a hearing, and I might have been able to say something there. That's not enough to require a reversal, especially in the fact that he did not request a hearing. The court found that the husband had acted continuously to delay proceedings and obstruct proceedings. The court specifically said that the court had personal knowledge of these facts because of the many pretrials and many discovery conferences that the court had to participate in as a result of conduct that she attributed to the appellant. The court had personal knowledge of all the extra time and certainly had a basis, in addition to the timesheets that were submitted, to award the fees. Under 3105.73, the only finding required by that statute is that the award is equitable, considering the assets, the income, the temporary support, the conduct of the parties, and any other relevant factor. The court specifically found that the award of attorney's fees would be equitable. The court specifically considered the assets, the inadequate temporary support, she made a specific finding of that, and then went on to describe the conduct of the appellant. Now, he says that the court awarded almost all of the attorney's fees. The court awarded $90,000 out of $253,000 worth of attorney's fees. There's 250-some thousand, I'm not sure the exact number. And by the way, that was consistent with the attorney's fees that were charged and by the appellant's counsel. So the court did not award substantially all of the attorney's fees.
except that his side gave him, what, $60,000?
He did, but it was still substantially more than the 90,000 that the court awarded. So the court did consider all of these factors, had a lot of personal knowledge. There's a lot of case law out there that says where the court has personal knowledge, the court can make a determination even without additional evidence. But there was evidence in this case, and we believe that there was no prejudice in the failure to allow him additional time to respond, given the fact that he had only challenged the payments in his motion, and those payments were undisputed.
Couple of questions. Did the affidavit contain an hourly rate, a statement as
Yes.
to reasonableness?
Yes. Hourly rate, $350 an hour, and did allege that the reasonable amount of attorney's fees was, I think it was between $250,000 and $300,000 was what he said in his
The
affidavit.
second question is, did the court apply the Bittner analysis, and was it, if not, was it required to determine that lodestar amount?
Well, the presumption is that the court followed the law. The court followed the right procedures. The real question that I think is raised in this appeal is, does the court have to show its math? And I think that's pretty clear under prior precedent, that the court doesn't have to go through and show all of its calculations. So is there any evidence in the record to show that the court did not follow the Bittner analysis? And there is not. Okay? The presumption is that the court did follow all of the proper procedures. The calculations, the specific numbers were not shown, and the case law says that that's not required.
Thank you.
Are there any other questions about the attorney's fees? If not, I'm going to move to the other issue. First of all, there was no request for de facto termination. There was no determination that there was a de facto termination of the marriage. There's no assignment of error that there should have been a de facto termination of marriage. The marriage was 24 years in duration. That finding stands. The second thing is that the appellant cites 3 different criteria to determine whether or not an indefinite award of support is permissible. And what he fails to say is the case law says that any one of those factors being present is sufficient to justify an award of indefinite support. It doesn't have to meet all 3 criteria.
So you're talking the length of the marriage, the
That's
wife's
enough.
resources, and the
Right.
rest when you talk about
The length of the marriage, the ability to obtain employment, the health of the parties, those are all considerations, and in different cases, they've been applied. But any one of those factors is sufficient to justify an indefinite term of support. Now, in this court has held in many cases that an indefinite award of support does not mean that support lasts forever, because the court reserved jurisdiction. In this particular case, the court said that at any time after he retires at age 62 or later, and he was already 65, so essentially any time he retired, the court would reconsider the issue of support. If the court had awarded 13 years of support, it might have been actually longer. If he continues to work and making $400,000 a year, then obviously support is justified. And the court made 4 pages of findings justifying her decision to award support, analyzing each of the spousal support factors. I don't know what more he could have asked for. The court found that she had given up her career in order to raise the children. She had there was a vast disparity of income. They had a high standard of living. All of the factors that would justify the award of support. And he has alleged that, well, she could have been employed. Well, the court actually found, and there was evidence in the record, that she was employed. The appellant represented she did nothing. She tried to start a business. She worked at that business for a couple of years and it failed, okay? Then she was caring for her mother full-time, a caregiver for her mother, an 83-year-old woman. But she was also doing arts and crafts. She was trying to sell things. She just wasn't making very much money. She was making, according to the court's findings, $175 a month. Now, the court found, well, she could probably make more, all right? And the court awarded or considered her earning capacity to be minimum wage. There was no evidence.
Counsel, you've got about 3 minutes.
Okay, there was no evidence that there was any other, I mean, he didn't present like some kind of expert testimony as to what she could have made. There was nothing in the record. Okay, finally, the income tax liability. This really upsets me to some degree. There's an agreed order that he's going to pay the taxes, all right? And there was consideration for that agreed order. And now he wants to say, well, she should have paid in the form of an offset of property some of the taxes. He agreed to pay the taxes in an agreed order filed prior to the case, and now he's appealing from that agreed order, which essentially, I mean, not really, he didn't actually file a notice of appeal from that agreed order, but there's no basis on which you can claim that she's not entitled to have him pay the taxes because he got the benefit of her deduction. That just bothers me. The final assignment of error, since it wasn't addressed in argument, I'm going to let the brief go on that. Essentially, that's a tracing issue, and the court found that there was no evidence of tracing, and it was his burden of proof. He didn't meet that. Are there any questions? Again, I apologize for the misstatement in my brief about granting that order when it was denied. Thank you.
All right, thank you for your argument. And counsel, you have 2 minutes and 49 seconds to reply.
Thank you. Very briefly, we can only respond when we're giving an opportunity to respond. The court denied that opportunity when she denied both proposed entries that we submitted with our motion to strike. We asked for time to reply on a substantive basis to the attorney fee time that was submitted. We were denied. We can't just file things. We have to be given leave. This was after a trial. That's the proper procedure. You ask for leave, it's denied. You don't just file things. Second of all, the affidavit that was submitted says literally nothing about the time that was expended in the case. The affidavit of appellee's counsel that was submitted with their closing argument on a timely basis says my hourly rate is $350 and this case should have taken between $250,000 and $300,000. There's nothing in that affidavit about his time that he spent on this case or the commitment, whether it was taking away from other duties, all the things that you would normally have to cross-examine on in a hearing. It's not there. Nothing about the time that was expended extra because of delays. We dispute there was any delay. It took 2 years just to get a decision on the validity of the prenup. And then we had a normal discovery process and we had a normal case after that happened. 90 out of 260 is not the number. We, appellant, paid a substantial amount of attorney fees to appellee throughout the case, and all that information is in our brief. $60,000 of the attorney fee submission that the judge noted, there was no affidavit for because it was for a prior counsel. $60,000 is noted in her judgment for attorney Lisa Dean. There's no submittal by her in the final time submission that was made by appellee. The only affidavit was her present counsel and the time provided by her present counsel. In terms of the indefinite award, I think most of what the trial court did is analyze the support factors that would go to the amount of the support, their lifestyle and how much she needed to live. The factors that go towards whether or not it should be an indefinite award were not analyzed, and those are all forward thinking. whether the parties are advanced age, whether the parties have an opportunity for employment.
Council, the court did keep jurisdiction.
Right, but I think the problem in this case, Your Honor, is that my client's income is only $100,000 of earned income, $300,000 of investment income. So what happens when you retire? He still has $300,000 of investment income. He's not going to just hopefully have no assets. He's not in a position to just retire. Number one, because he has substantial obligations to his children that he's keeping them, supporting and paying for college and all that. But secondly, even if he retires, the only thing that goes away in this case is $100,000 of earned income. He's still going to have investment income. Theoretically, he'll still have his investment. So it doesn't end. And you have people, he's 65, she's 55 at the time of the trial. He could live 20 or 30 more years, that this obligation could be there for a 20-year marriage. We don't think that is equitable. We think it's unreasonable. There's no way this will end for him and her in this case. It's a very fact-specific type of situation. You can't just retire and say, well, I don't have to pay anymore. It's just not going to be a mechanism for him to get the support terminated. Not reduced. I understand it may reduce, but it will never end. And he has a lot of life left, and so does she.
Counsel, I wanted to let you answer that question, but your time is up.
Okay. Thank you very much.
Thank you both for your arguments and presentations today. The court will take the matter under advisement and issue a decision in due course. The courts will mail a copy of the decision to each of you the day it's released. Also, the opinions are posted on the Supreme Court of Ohio's website. So again, thank you for your arguments and the brief.